we're seeing a trend in favor of severance agreements. So, you know, given the cost of litigation, a lot of employers are deciding that when they're letting someone go, just to make it a sort of a standard practice to offer a severance agreement, do it in a formulaic way. You might have an exception for misconduct. You know, if somebody did something, harassed someone, or there was violence, that would be a different category. But if they just weren't able to perform, or of course, if the job is eliminated, then we're seeing a big trend in favor of severance agreements. And as Kevin is going to explain in a minute, if I often get requests from clients to just look over a severance agreement, and often they're recycling older versions, which I completely understand, but you'll want to be aware that anything that's more than a year or so old is very likely to be out of date. So there have been some significant changes, and one of them has to do with confidentiality.
Yes, hi everyone, my name is Kevin Jones. I am also a senior associate in the employment practice group, and I will try to speed right through this so we can get to the reception and fun times. So there are basically, we're going to talk about both federal and California developments with respect to confidentiality and non-disparagement provisions. And you'll see that both with the National Labor Relations Board, the NLRB, and California, that there are more restrictions on both in severance agreements and in settlement agreements surrounding your confidentiality and non-disparagement provisions. So I'm going to talk about McLaren, and then Holly is going to talk about California law that has come into effect recently. So McLaren-McComb is a recent NLRB decision that came out in 2023, and it sort of rocked the world as far as for labor and employment attorneys. And while you're thinking maybe, well, I work for somewhere that's not unionized, does this apply to me? And the answer is, I'll just spoil it, is yes. Because your workplace could become unionized, and there are employees that potentially could engage in activities soliciting unionization. And so the NLRB and this decision still can impact them. And so what happened in this case is there was this teaching hospital in Michigan, and it was during the time of COVID where there were a lot of cutbacks in a lot of places, and 11 hospital employees were furloughed, and then they were eventually permanently furloughed. And so, and the employer approached them about severance agreements that included a confidentiality provision and a non-disparagement provision that I'll show you in a moment. But the first big no-no that actually happened in this case is that the employer approached these individuals who were unionized. And I should have said this employer had both non-unionized employees and unionized employees. These 11 employees were unionized. And the first big no-no that happened was that these 11 employees were approached without their union representative being approached. So that was the first violation. And when these employees filed a labor unfair practices charge, the administrative law judge found that that was a violation. But it ended up going to the NLRB about these confidentiality and non-disparagement provisions that we're going to talk about in a moment. So the non-disparagement and confidentiality agreements are on the screen or on the slide. I'm not going to exactly read them, but what I've done is highlighted sort of the key operative phrases. And if you've been sort of in HR or in legal for a while, you probably at first wouldn't think that there's anything wrong with these. These are very standard, and that's true. However, in the political climate that we're in, the NLRB tends to be more pro-union and pro-employee. And they basically rejected the Trump era Republican-controlled NLRB and rejected sort of prior precedent and set more progressive precedent and said that these very broad language in this pretty much prevents employees from being able to engage in what are called Section 7 rights, which are basically the ability to solicit potential unionization. Because as you can kind of see, that those really broad provisions could prevent someone from doing something like going on social media and talking about their employer. From an employer standpoint, you probably don't want that employee bad mouthing you, and so it's been a common practice to include that. But you can see how from the NLRB's perspective, if you're restricting an employee from tweeting about the company and how unfair they are, that could actually be restricting how they're engaging with other people outside of the company to help unionize. So what this basically says is employers need to go back to the drawing board with these really broad confidentiality and non-disparagement provisions. It has a retroactive effect, meaning that it affects all agreements. We do note that may end up being challenged in the courts, but for now, that is the law. And like I said earlier, this includes non-union employees because they could become unionized. The only folks that maybe will be carved out are supervisors, because generally speaking, supervisors cannot become unionized. And that's a whole labor law section that we need to talk about, but I'll leave it to Holly to talk about California stuff.
Yeah, and I'll just add to Kevin's point. So what this means is when we're doing layoffs, for example, we'll have now two templates. One is for your supervisors, where we can keep in a lot of this non-disparagement confidentiality language that we're all very familiar with. And then we have a different template for your hourly employees who do have these Section 7 rights, even though you're non-union, because the Act applies to all employees and protects their right to concerted activity. So we're really paring back on what we're going to put into these confidentiality and non-disparagement provisions for non-supervisory employees. And again, the difference between supervisor and non-supervisor is a little different under the NLRA than under other laws. So there's a whole, as Kevin said, a determination to be made, but something many employers are just deciding, especially in light of what I'm about to tell you, it's not worth the bother. And we've long had concerns about how enforceable some of these provisions are, keeping in mind, of course, that your trade secrets are absolutely protected. You can prevent your employees and your former employees from disclosing proprietary confidential business information. But trying to prevent them from criticizing the company is a very different story, right? So we have two big broad categories here. In terms of California law, we have some slides that kind of give you the history of these relatively new laws, and much of it goes back to the Me Too movement. We're still very much in the shadow of that movement, and the general sense, public policy sense, that contracts or policies that prohibited employees from complaining about unlawful acts in the workplace was counter to public policy. And you had the Harvey Weinstein example with dozens of people who had been assaulted and essentially were afraid to speak publicly for fear of personal liability, or to go to the agencies. So where we end up on this, and there's been an evolution, which kind of ends up, I'm actually going to go to this slide, which is that you cannot, it is unlawful in California to have an agreement that prohibits an employee from disclosure about unlawful acts in the workplace. And this could include just your standard confidentiality clauses in your handbook. So keep an eye on that. Just a nice carve out that says, and you'll see the language here in the second paragraph, this is what the statute requires. This quote, nothing in this agreement, or you could say in this policy, prevents you from discussing or disclosing information about unlawful acts in the workplace, such as harassment or discrimination or other conduct that you have reason to believe is unlawful. very broad, right? So this is a subjective determination. Did the employee have reason to think what they were saying, reporting was unlawful? If so, you don't want any provisions that are purporting to restrict them from sharing that information. So you'll see in all the current templates and hopefully in your current severance agreements, you have this carve out in there that makes it clear that they are absolutely entitled to discuss or disclose information about unlawful acts in the workplace. Just as an aside, because that's about all I'm going to share on this point, there's more that we can talk about, and some employers are asking, why should I even have confidentiality clauses? And I would say yes, but just have the right carve out, because you probably do have other information you don't want shared. And your confidentiality agreements can prevent the claimant from disclosing the monetary settlement, the amount of the settlement, which is often a sensitive point. And other information that's completely unrelated to unlawful acts in the workforce. So there definitely are still benefits to that. And of course, often these are negotiated. So sometimes we'll start with these provisions and then, and thank you, Kevin. Kevin's reminding me that here's our slide. And this is in the material that if you put one of these agreements in front of someone and they don't want to sign it, that is now a protected activity. You've heard a lot today about retaliation claims. I think we would all agree that retaliation claims are among the more dangerous types of claims. So you definitely want to clean up your forms is kind of what we're saying, and make sure you don't have these outdated provisions in those forms. So, okay, with right at the top of the hour, we're going to take some questions.